In case we have never met, I'm Michael Price, and I want to help you succeed in the GSA and VA contract world.
I'm Nancy, your co-host, and today is August 17th.
Welcome. I'm Michael Price, your host.
If you are listening to this, you are here because you have that drive to see major structural shifts in business and law before they actually hit your bottom line. You want to stay ahead of the curve.
Right. Absolutely.
So I want you to imagine you are trying to get into this highly exclusive, incredibly lucrative VIP club.
Okay, I'm with you.
And for years, you were on the VIP list based purely on, say, your last name or your demographic profile. The bouncer looked at you, checked the list, and just waved you through, to ensure a fair mix of people got inside.
Yeah, a fast pass, basically.
Exactly. But today you walk up to that exact same velvet rope, and the bouncer, well, he doesn't care about your demographic at all anymore.
He's asking for a completely different set of credentials.
Right? Instead, he demands this huge stack of sworn corporate affidavits and court rulings proving that the club next door actively discriminated against you and actually cost you quantifiable income.
Wow.
And he needs all that before this club will even consider letting you in. The entire architecture of how you gain access has just been flipped upside down overnight.
I mean, that VIP club analogy, it perfectly captures the systemic shock we are looking at today because, we tend to assume bureaucratic processes move like glaciers, right? Like they take years to fundamentally alter their course.
Yeah, usually they drag on forever.
But when a foundational legal mechanism is just struck down by a court, the entire landscape changes instantly. And the new reality we are looking at, well, it requires a completely different mindset for anyone trying to navigate it.
It really does. So today we are dissecting an August 17th, 2026 legal briefing. This was published by the law firm Davis Wright Tremaine and written by partner Anne-Marie Tavella.
It's a really thorough brief.
It is, and our mission for this deep dive is to map out the sheer scale of this new terrain. We are breaking down a massive overhaul to the U.S. Small Business Administration's 8 Business Development Program.
Which is huge for federal contractors.
Massive. This is a fundamental rewrite of federal contracting rules going into full effect on September 10th, 2026. So we'll explore the constitutional trigger that forced this change, the incredibly rigid new evidence rules businesses have to follow, and the underlying paradox of how raising the barrier to entry might actually flood the system with entirely new applicants.
Yeah, that paradox is wild. But to really grasp the magnitude of the September 10th rule, we first have to understand the specific legal machinery that just got dismantled.
Okay, let's unpack this. Where do we start?
Well, the 8 program is a total cornerstone of federal procurement. It traces its roots all the way back to the Small Business Act of 1953.
Wow, so it's been around for over 70 years.
Exactly. And the government has this statutory goal to award at least 5% of all federal contracting dollars to small disadvantaged businesses.
Right, and for decades, the SBA managed that goal by relying on a mechanism called a rebuttable presumption.
Yes, the rebuttable presumption.
Basically, the federal regulations presume that if you were a member of certain designated racial and ethnic groups, you were inherently socially disadvantaged. Like, you showed you belonged to the group, and the system just assumed you faced societal hurdles.
It streamlined your entry, yeah.
But a couple years ago, the legal foundation of that fast pass just completely cracked, didn't it?
It did. The crack really started with a 2023 case called Ultima Services Corps v. U.S. Department of Agriculture. A federal court in Tennessee looked at this system and delivered what was honestly an explosive ruling.
What did they say?
The court held that using this rebuttable presumption based on race and ethnicity violated the Equal Protection Clause of the Constitution, so they outright barred the Small Business Administration from continuing to use it.
So wait, I want to pause on the mechanism there because federal judges don't just strike down decades-old federal programs on a whim. This comes down to the concept of strict scrutiny, doesn't it?
That is the exact legal threshold. Yes. Whenever the government uses a racial classification to distribute benefits or burdens, for that matter, the courts apply strict scrutiny.
And that's a really high bar to clear.
Incredibly high. The government has to prove it has a compelling interest and that its policy is narrowly tailored to achieve that interest. And in the Ultima case, the court determined the SBA just failed that test.
They couldn't justify it.
Right. They couldn't sufficiently justify relying on broad group-based presumptions rather than, individualized assessments of disadvantage. So the SBA was immediately blocked from using demographic identity as a proxy for social disadvantage.
So the SBA is trapped. The courts literally just outlawed their defining metric. How do you even legally define disadvantage without using race or ethnicity at that point? The immediate aftermath of that 2023 ruling sounded like total chaos.
Oh, it was. The agency essentially panicked. They implemented this stopgap measure where they started requiring individually owned firms to submit detailed personal narratives.
Personal narratives, like an essay.
Yes, applicants had to write out their personal experiences of social disadvantage to prove they deserved entry into the program.
Oh my gosh, I can only imagine the administrative nightmare of that. You have thousands of business owners suddenly having to write personal trauma essays, and then government officials who are, procurement officers, not sociologists, having to subjectively grade them.
Exactly. Having to grade them to decide who gets a federal contract. It was wildly unsustainable. The process was subjective, it was inconsistent, and it created a massive backlog.
I bet.
The narrative approach was always just a temporary bandage, to keep the contracts flowing while they figured out a permanent legal framework.
And so this new September 10th rule is the permanent fix?
Right. The final rule that Davis Wright Tremaine is detailing today completely eliminates that subjective narrative approach. They ripped off the bandage and replaced it with a highly rigid legal test.
Well, whenever there is a massive regulatory shift like this, my immediate thought goes to the businesses currently standing on the rug being pulled out from under them.
Yeah, absolutely.
Like, if the underlying justification for the program was ruled unconstitutional, does every current 8A contract instantly vaporize? Do the businesses already in the program have to just start over from scratch?
No, thankfully not. The source material provides a very clear answer on this. The final rule has specific built-in exemptions to prevent the immediate collapse of existing contracts.
Okay, that makes sense.
Yeah. First, it does not require individually owned firms that are already participating in the 8A program to reestablish their social disadvantage under the new rules. If you are already through the door, your current status is protected.
Okay, that is a massive carve-out for current participants, but the briefing also mentions that large entity-owned businesses are completely exempt from this new rule, too.
Yes, they are.
We are talking about Alaska Native corporations, tribal organizations, Native Hawaiian organizations, and community development corporations. Why the double standard there? Like, why are tribes legally exempt from this constitutional overhaul while minority-owned private businesses aren't?
It's a really good question, and it comes down to a fascinating distinction in federal law. The exemptions for tribal organizations and Alaska Native corporations survive because their relationship with the federal government is considered a political classification.
Oh, a political classification, not a racial one.
Exactly. It's based on tribal sovereignty, not racial classification. And because it is rooted in political sovereignty and that government-to-government relationship, it does not trigger the same strict scrutiny under the Equal Protection Clause.
So the legal mechanism that dismantled the individual demographic presumptions just doesn't apply to them.
Right. Therefore, their statutory exemptions remain totally intact.
Okay, that distinction makes perfect sense of the legal map. So to be precise, this sweeping new rule only applies to new individually owned applications that are pending on or after that magic date of September 10th, 2026.
Spot on. If your application hits the desk on September 11th, you are subject to the new standard.
And that new standard is a strict two-prong requirement that applies to any U.S. citizen applying.
Any U.S. citizen. Under the revised rules, you can't just claim society's generally unfair. Prong 1 requires you to show that a specific government or private entity, like a state agency, a university, or a corporation, discriminated against a racial, ethnic, or cultural group to which you belong.
Okay, so you need an institutional actor. You have to point to a specific policy or action by an organization or that they favored another group over yours.
Exactly. That's prong 1.
And what is prong 2?
Prong 2 requires you to prove that this specific institutional discrimination caused you, the individual applicant, material economic harm.
Material economic harm. That phrase right there carries a lot of legal weight.
It really does.
That means you can't just be, offended by a corporate policy. You have to show it hit your bank account or your career trajectory in a measurable, quantifiable way.
Yes, you have to self-certify that you belong to the affected group at the exact time the policy was in place, and that you personally experienced this economic fallout.
Like losing a bid or something.
Right. Like being explicitly denied access to a government program, losing a specific contract bid,
Hmm.
or just being shut out of an economic opportunity specifically because of that precise policy.
Okay, here's where it gets really interesting. Knowing the two-prong test is one thing, but proving it is entirely different. We are moving from the abstract rule to the concrete reality of what you have to attach to your application,
The paperwork is going to be intense.
right? The burden of proof has shifted completely. In the old days, your group identity was essentially the proof. Now the SBA is demanding heavy receipts.
Heavy receipts is the perfect way to phrase it. The final rule is incredibly explicit about what constitutes acceptable evidence. You cannot rely on broad societal statistics anymore.
So no general reports on inequality?
No. The SBA states that evidence supporting your claim must include tangible documentation. We are talking public policies, government or corporate documents, court rulings, or official statements.
Wow, so you are essentially being asked to act as your own civil rights lawyer, building this documented evidentiary case file just to get permission to bid on a federal contract.
It's a huge burden.
And just to be clear on our end for you listening, as we navigate the specific examples of what the SBA considers discrimination, our job isn't to weigh in on the politics of diversity initiatives or affirmative action here.
No, not at all.
Right. We are strictly mapping out how the Davis-Wright-Tremaine briefing outlines the government's new legal definitions based on this specific SBA rule. We're just the messengers.
And that neutrality is important because the SBA's listed examples are frankly at the center of intense national debate right now.
So what are the examples they actually list?
According to the rulemaking, valid examples of institutional discrimination that applicants can cite include race-based quotas, specific hiring targets, unlawful diversity, equity, and inclusion policies.
Wait, DEI policies are listed?
Unlawful ones, yes. Also, unlawful affirmative action programs. And policies that expressly favored certain racial or ethnic groups over others.
I mean, the inclusion of DEI and affirmative action programs as explicit examples of discrimination that you can claim harm from, that is a massive pivot for a federal agency.
It really is. And the source text actually brings up some heavy-hitting Supreme Court cases to illustrate the legal framework for these claims.
Yeah. The briefing mentioned Harvard, right?
Yes. The SBA rules commentary explicitly points to two major Supreme Court decisions to serve as blueprints for applicants. The first is that 2023 case, Students for Fair Admissions Incorporated, v. President and Fellows of Harvard College.
Right, the landmark case that dismantled the use of race in university admissions.
Exactly. That ruling established that historical discrimination does not justify current race-conscious metrics without a highly specific, measurable endpoint.
And there was a second case, too.
Yeah. The second case the SBA cites is from 2025, Ames v. Ohio Department of Youth Services.
Okay, what did that one do?
That was a crucial precedent regarding reverse discrimination claims in employment. So by citing Harvard and Ames, the SBA is basically providing a roadmap.
Giving them the exact legal theory to use.
Yes, they are telling applicants, look at the legal frameworks used in these Supreme Court cases. If you can prove you suffered material economic harm from similar institutional policies, you meet our new standard for social disadvantage.
So wait, let me just follow the logical thread here. If the demographic requirement is totally gone, and the new test is simply to prove that an institution's policy favored another group over yours and caused you economic harm. Does this mean a white male applicant who lost a government contract specifically because of a municipal affirmative action quota could now claim social disadvantage and enter the 8 program?
You just hit on the great paradoxical twist of this entire regulatory overhaul. Yes.
Really?
Really. Because the SBA was forced to remove the presumption of disadvantage for specific minority groups, the program's demographic walls have been completely leveled. The new rule explicitly states that any U.S. citizen can now apply to establish social disadvantage.
Any citizen who can prove harm.
Any citizen. If you can document that you lost an economic opportunity due to a policy like a race-based quota or a specific diversity target, you can qualify.
That is just wild to think about.
And the Davis-Wright-Tremaine briefing highlights a staggering reality regarding this. Individuals who were previously denied admission to the 8 program because they did not fit the old demographic, presumptions might actually be able to use that very denial letter as evidence to get in now.
Oh, wow, that completely flips the script. Let's say, 4 years ago, a business owner applied to the APE program. The government sent them a formal rejection letter stating they didn't qualify because they weren't part of the designated groups the program was prioritizing.
Right, a standard rejection.
Under these September 10th rules, that business owner can take that exact rejection letter, submit it to the SBA, and argue, hey, here's a government document proving I was denied an economic opportunity based on a policy that favored certain groups over others, and this caused me material harm.
The briefing anticipates exactly that scenario. Now, to be clear, a prior denial doesn't grant automatic entry.
Sure, they still have to meet other requirements.
Right. The applicant still has to satisfy the program's separate economic disadvantage requirements, meaning they still have to be a small business under the specific revenue thresholds. But regarding the social disadvantage hurdle, that prior rejection letter becomes highly potent evidence.
Wow.
And the article notes this could trigger a massive influx of applications from individuals who would never have legally qualified before.
So the door isn't closing. The barrier to entry requires much more paperwork, but the pool of potential applicants could literally explode.
Exactly.
And the federal government's goal is still to award 5% of contracting dollars to these businesses. If the pool of eligible businesses substantially expands, competition for that 5% is going to become incredibly cutthroat.
The slice of the pie remains exactly the same, but the number of businesses legally entitled to grab a fork might multiply exponentially.
I imagine this doesn't stay contained to just federal contracts either. I mean, a rock thrown into the federal pond of this size is going to make waves at the state and local levels too.
Oh, absolutely.
If the federal standard for defining disadvantage has completely shifted to individualized economic harm, that puts a massive target on the back of every state and local program doing the same thing.
It is triggering a nationwide domino effect. While this final rule directly governs the federal APE program, Anne-Marie Tavella's briefing makes it clear that this is accelerating a broader legal movement across the board.
So what does this all mean in practice?
Well, we are seeing a rapid shift away from any eligibility presumptions, preferences, or participation goals that turn expressly on race or ethnicity across the country.
Where are the dominoes falling right now? What are the real-world examples the briefing provides?
The U.S. Department of Transportation is a prime example. They have already responded to this shifting legal landscape by removing racial and ethnic presumptions from their disadvantaged business enterprise programs.
And those are massive programs.
Huge. And they did the same for their airport concession programs. They are now requiring funding recipients to completely reevaluate eligibility before using participation metrics toward their contract goals.
So massive infrastructure, highway and transit projects are already rewriting their internal compliance rules just to keep up.
They have to avoid litigation. And on the state and local front, the legal battles are becoming highly contentious. The briefing highlights an active lawsuit in Missouri right now.
What's happening in Missouri?
The state of Missouri's Attorney General is actually suing Kansas City in federal court.
Wait, so the state is suing its own city?
Yes, the state is actively seeking an injunction to stop Kansas City from operating its minority and women-owned business programs, arguing that the city's programs are unconstitutional under these exact same legal interpretations.
That is incredible. You have a situation where local municipalities are literally being taken to federal court by their own state governments over these definitions.
It's a huge liability.
And I guess the reason cities are so vulnerable is that municipal governments often just copy-pasted the federal SBA definitions for their own local ordinances, right? Now that the federal foundation has collapsed, the local codes are legally defenseless.
The exposure is immense. Administrators across the country have to expect that any classification they use is going to face microscopic scrutiny.
They really need to audit everything.
Definitely. They have to ask themselves if their program is supported by specific evidence of identified discrimination, if it is narrowly tailored, and if it can survive the strict scrutiny standard the SBA failed to meet in the Ultima case.
The takeaway here for you listening is crystal clear. If you are involved in any program, whether it is a local municipal grant, a university fellowship, a corporate credit initiative, or, a massive corporate supplier diversity program that relies on the old historical definitions of social disadvantage, you are facing serious imminent litigation risk.
The days of relying on broad, generalized demographic presumptions to allocate resources are officially over. The standard now requires individualized, documented proof.
We have covered an incredible amount of ground today. Let's just recap this journey real quick. We started with a 1953 federal mandate designed to help disadvantaged businesses secure a foothold in government contracting.
Yep.
For decades, it operated with a rebuttable presumption, that demographic fast pass we talked about. But after the 2023 Ultima court decision ruled that mechanism unconstitutional under the Equal Protection Clause, the SBA was forced to adapt. And after a chaotic period of requiring subjective, personal essays, the government finalized a sweeping new rule.
And effective September 10th, 2026, that new standard is a demanding two-pronged test. It requires concrete documented proof, receipts like court cases and corporate policies showing you suffered material economic harm due to institutional discrimination.
A strict test that paradoxically opens the doors to any U.S. citizen who can prove that harm, potentially flooding the system and hypercharging competition. And whether you are an entrepreneur trying to secure a federal contract, a policy watcher tracking that Missouri lawsuit, or just a curious learner trying to understand the nuts and bolts of how our legal and bureaucratic systems adapt to constitutional challenges, this rule change fundamentally rewrites the rules of the game.
It really does.
It illustrates how a single federal court ruling can just ripple outward, reshaping Department of Transportation rules, triggering lawsuits against cities, and redefining literally billions of dollars in economic opportunity.
It drives home the reality that in today's legal environment, identity alone is no longer an acceptable proxy for disadvantage in the eyes of the court. The currency of the realm is now documented economic harm.
Which brings me to a final thought for you to mull over today, building on everything we just discussed. Think back to that VIP club analogy from the beginning of the deep dive.
It is, yeah.
We've seen the requirement for entry shift from a simple demographic nod to demanding a literal legal dossier of personal economic harm. If the legal definition of what it means to be socially disadvantaged continues to broaden, driven entirely by individual lawsuits, specific claims of reverse discrimination, and quantifiable financial hits rather than historical group presumptions, how will the government eventually define a small disadvantaged business in 20 or 30 years?
That's a great question.
Will demographic categories just disappear entirely from government contracting and corporate diversity initiatives, leaving us with a system based purely on localized individual economic metrics and class-based algorithms?
It is a profound question, and if history tells us anything, the rules of the game are never truly final. They just evolve to meet the next legal challenge.
Something to keep a close eye on as September 10th approaches. Until next time, keep digging, keep questioning, and keep looking for the shifts before they happen.
Thank you for watching. If you're interested in becoming a sponsor and sharing your product or service with the world, reach out to MarketUS.com. You can schedule a session to discover how we can work together. See you soon.